market participant from it. What happens? The NFL appeals, it goes to the U.S. District Court of Appeals. What happens? Reversal. 900 lawyers all dealing in the field, all wrong. The Court of Appeals based its decision solely on an arcane piece of federal or Supreme Court precedent called the non-statutory. I like to call it the double secret labor exemption. It's a non-statutory labor exemption. It comes from a couple of case doctrines, Pennington, and a case called Jewel T. And interestingly enough, it says that even though it might not be perfectly recorded in the collective bargaining agreement, even though it might just have been the subject of negotiation, if the union and the league agree to have it, we'll give it its full force and effect. It is clearly the most incredibly pro-union piece of dicta ever put forth by the Supreme Court. And it comes out of the 1970s and 60s when the Supreme Court was incredibly pro-labor. It comes out of a Warren court, essentially. Guess who applies it? Scalia. Thomas. The most conservative anti-labor court is using this piece of labor, but they ultimately give the NFL and all the sports leagues their victory. And now, as long as the league and its union can agree, whatever is the subject of their agreement will get the full force of law. That is, on some levels, a little scary. On some levels, it is actually one of the best opportunities now for sports to be rebuilt. And it should be rebuilt through the collective bargaining process. And since the Supreme Court of the United States denied cert to this case, they went to fix it. Now, what do you got in sports? You got an interesting situation. Do you have real unions in sports? Not really. You know why? Because in most of sports, except baseball, they have a salary cap. And what does that salary cap based on? It's based on the union getting a certain percentage of revenue. In football, for every dollar management takes in, including the television contract, not including new media now, that's the new carve-out for management, the Players Association gets 60 cents on every dollar earned by management. Who here has worked in a service industry? Yeah. 60 cents on the dollar for every dollar taken in. You want to go to a law firm and ask for that next year? Get Gene Upshaw to represent you. Yes. Nobody gets that. In fact, if you're paying your labor more than like 30 cents on the dollar earned, you're doing real well. So that's the first thing. Unions in professional sports, except baseball, which actually really is a union still, and very litigious and very aggressive and adversarial with management, most of the other labor unions are really, I would describe as in-house unions and essentially partnership structures. They're almost like the European trade unions where they have a seat on the corporate board as opposed to being an adversarial employee relationship. But that provides an opportunity because it provides an opportunity for the unions and the leagues to recognize where their model isn't working and move forward toward a fix. Commissioners have a couple other arrows in their quiver, and I'll talk about them only briefly. The commissioner has the best interest power. It's almost the thermonuclear protection that all the league's commissioners in their charters have. These are contractual rights and contractual remedies, but essentially it's a very powerful thing. We've seen it mostly in baseball. The best interest of the game, where the commissioner has voided trades or prevented owners from doing certain things. And remember, in baseball, the owners don't have the ability to allege that there's been an antitrust conspiracy against them because baseball has antitrust immunization. But in the other sports, they still have the best interest power. It's a little bit limited. It needs to be rationally related. There needs to be a rational and causal connection and not arbitrary and capricious, but we still have the best interest power. So could Jim Dolan or could David Stern act to fix the Madison Square Garden situation by suspending Jim Dolan for allowing blatant sexual harassment to take place in his shop? Or particularly when someone came forward and alleged a complaint, what did he do? He fired the person? I believe that would be retaliation or the definition. Yeah, he probably could. Is it a fight as commissioner he's necessarily going to pick by suing or by starting off a 7-year legal fight? I don't know. I don't know. But the best interest clause clearly exists. The gambling clauses are another commissioner power that have come about in light of the fact that commissioners were created in light of the Black Sox scandal. And the gambling power really gives commissioners pretty much unfettered power if you can involve someone in gambling. My speculation on the Vic case is that's exactly where Goodell was going if he was going to proceed under the to suspend Vic. He was sending off the former U.S. attorney to gather information about Vic's gambling activity, recognizing that no one probably goes to a dogfight for the pageantry and beauty of the sport. You go in a place of bet. And I think that Vic in the gambling clause fit Goodell better because the commissioner has relatively unfettered powers under the gambling clause. The expansion of personal conduct policies, which I'm going to talk about in a second, is where the NFL went. And this is actually the fun part about the Vic case, or the interesting part about the Vic case. This is the NFL's personal conduct policy, which I'm sure will be quickly amended. It will be considered conduct detrimental to covered persons to engage in or aid in or abet and conspire or engage in incite violent or criminal activity. Examples of such prohibited conduct include, without limitation, threats of violence to persons or